Good morning everyone, my name is Michelle, I hope you're doing well. Welcome to another video. It's Thursday the 8th of February, and after I logged off my live stream last night where I went through the motion to dismiss the case, and here of course we're talking about the Delphi case because Delphi's my life now. Soon after I logged off there was yet another court filing. This time it was by someone called Michael Ausbrook. Who's Michael Ausbrook, I hear you say? Well, yeah, the first hit that comes up on Google is Murder Sheet Podcast because they interviewed him recently. So he's a professor at the Indiana University Moore School of Law. He's director of the habeas project there. He's got years of experience working habeas cases. Also serves as a board member of the Indiana Public Defender Council. Not a lot on his LinkedIn. Let's have a look at his university page here. Alright, okay. So he's a professor, a law professor. So he's going to know the law, right? Yeah, of course he is. Well, he's took the trouble to write an 8-page filing in support of Andrew Baldwin and Brad Rozzi, literally tearing a new one off Slick Nick McClelland and his ridiculous motion for contempt of court. So we're going to read this. It's quite law heavy. I'm not a lawyer in Indiana. I'm not a lawyer at all. Bear that in mind as we go through. So for the reasons that follow, the court should summarily deny the state's information for the contempt of court, contemptuous conduct. There's a hearing on this in just 4 days' time. Both Baldwin and Rozzi have filed to get this either continued or vacated. Rozzi's even out of the state Monday, 9 a.m. Indiana time. I don't know whether they're going to televise it. Maybe she'll let cameras in. I don't know. I haven't heard. Same time as Adam Montgomery's trial starts, if it gets that far. If you're following the Adam Montgomery trial, you'll know exactly what I'm talking about. But if you want a mega quick catch-up, go over to Michelle Walks, and I did a 5.5-minute video summarising the whole thing. Okay, let's get into this video.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
So this is the introduction. The state's information has many flaws, not least among them is its failure to allege, either directly or by inference, either Mr. Baldwin or Mr. Rozzi committed any of the supposed offending acts willfully. So keep that in your head. But the state's information as to additional flaws that are fatal. Oh, I do love a good fatal flaw. Don't you, Nick? Oh, I bet you do. Okay, first, to the extent the state's information purports to allege indirect civil contempt, and it's not entirely clear what Nick is even filing for. Is it civil contempt? You would assume so. Or criminal contempt? If it's criminal contempt, you've got a big bar to jump over there. It fails to allege any act injuring the state that a remedial or coercive contempt sanction could redress. The state therefore lacks standing to pursue its information as one for indirect civil contempt, and this court lacks jurisdiction to consider it. Have you heard that, Francis? Do you care? No. Okay. Second, because there is no available remedial or coercive contempt sanction, any contempt sanction would necessarily be punitive and therefore for a finding of indirect criminal contempt. But to pursue indirect criminal contempt against Baldwin and Rozzi, the state would have to file its information in a separate criminal case. It's not done so, and this court has no authority to punish Baldwin and Rozzi for indirect criminal contempt in this criminal case against Mr. Allen. Yeah, it's ludicrous. So is McClelland going to file an entirely new case for criminal contempt, put this nonsense that Nikki has written in front of any other judge than Gull, and they'd take one look at it and they would laugh because it's so petty? There'd be no case to answer. Finally, were the court to impose, without jurisdiction or authority to do so, any necessarily punitive sanction on the state's information in this criminal case against Mr. Allen, it would be at least the second time the court has interfered with Mr. Allen's 6th, 14th Amendment rights to counsel. Are you listening, Francis? We've got a couple of important footnotes here, so in relation to this one, this is a written motion required by Indiana Original Action 2A, which provides, in relevant part, no petition for a writ of mandamus or prohibition be entertained unless the realtor has raised the jurisdictional question by written motion, which the trial court has denied or not ruled upon timely. The motion shall allege the absence of jurisdiction of the respondent court, or the failure of the respondent court to act when it was under duty to act. And then 2, in relation to the second time they've messed about with Richard Allen's attorneys, his attorneys of choice, at least one other time, of course, was when, on October the 12th, in an email, the court ordered Messrs. Baldwin and Rozzi to stop work on Mr. Allen's behalf. State interference with counsel in violation of the Sixth Amendment is structural error for which prejudice is presumed. Government violates the right to effective assistance of counsel when it interferes in certain ways with the ability of counsel to make independent decisions about how to conduct the defence. Oh dear, 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 dear. The state's information has not alleged an injury a civil contempt sanction can remedy. The state therefore lacks standing to pursue its information as one of civil contempt. As a matter of law, almost older than dirt, there are 2 kinds of contempt, direct and indirect. So direct contempt of court is when it's done directly in the presence of the judge. Like if you tell the judge to F the F off, that's probably going to be deemed contempt of court. Indirect contempt is acts committed outside the presence of the court, but nevertheless tend to interrupt, obstruct, embarrass, or prevent the due administration of justice. Is that what's happened in this case? No. Okay. It should not be a matter of dispute that the state's information at least attempts to allege Baldwin and Rozzi committed indirect contempt. None of the acts the state's information alleges were contemptuous occurred in the court's presence. Okay, so we know it's indirect, and that's what he has filed. All right. Sanctions for indirect civil contempt must be remedial or coercive for the benefit of an aggrieved party. So who would the aggrieved party be? Who's the aggrieved party, Nick? You? So what are you going to do? Sue them? Sue them for being good lawyers? Come on now. Come on now. If you're a member of this channel, you've got access to the emojis. Slam in some come on now emojis in the comments right now. Thank you. As a second matter of law, almost older than dirt, direct and indirect contempt each come from 2 varieties, civil and criminal. We've already talked about that. Sanctions for civil contempt are for the benefit of the party who has been injured or damaged by the failure of another to conform to a court order issued for the private benefit of the aggrieved party. So I say again, who's the aggrieved party? Who's the aggrieved party? The object of a civil contempt is the enforcement or protection of the rights of the complainant. Only a coercive or remedial judgment may be entered. Right, Slicknick, does he actually have a law degree? Does he? I'm just asking for a friend here, because he doesn't seem to have a great grasp of the law. How on earth did he get the job of prosecutor in Carroll County? Did no one else want to do it? Why is he there as a little yes man? Yap, 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 yap. He's like a little chihuahua yapping at people's heels, isn't he? Sounds really tough. But not actually an effective guardian, is he? No. Nothing against chihuahuas, by the way. I think they're lovely. Criminal contempt, on the other hand, is an act directed against the dignity and authority of the court, which obstructs the administration of justice and which tends to bring the court into disrepute or disrespect. So this is sounding more like what Slicknick is trying to argue. Sanctions for criminal contempt are intended to vindicate the authority of the court. You can be fined, you can go to jail. Okay, the state's information alleges no injury. Civil contempt sanction can meaningfully redress, and the state's resulting lack of standing to pursue its information means the court has no jurisdiction to consider. Even were the court to take as true every allegation of the state's information, no sanction imposed for any of the alleged contemptuous acts would remedy an injury to the state. Nor would it coerce Messrs Baldwin and Rozzi to comply with any order of the court the state's information alleges they violated. The court shall, on proper showing, extend the time provided under subsection B3 to give the defendant a reasonable and just opportunity to be purged of the contempt. The state therefore has no standing to pursue its information. The standing requirement is a limit on the court's jurisdiction, which restrains the judiciary to resolving real controversies in which the complaining party has a demonstrable, I can't say that word, injury. Only those persons who have a personal stake in the outcome of the litigation and who show that they have suffered or were in immediate danger of suffering a direct injury as a result of the complained of conduct will be found to have standing. Is that you, Nick? No. Okay. Without an injury meaningfully redressable by civil contempt sanction, the state simply does not have standing to pursue its information. Is it becoming clear to you now, Nick? Has this been repeated time and time again in this motion? Yeah. The reason being, it seems that Nick and Gull have the reading ability of a centipede, which means you've got to just keep repeating yourself to get it through to them. Not that it ever does. The state's information can only be seeking punitive sanctions for criminal contempt. The state filed it in the wrong place and has no authority to impose a criminal sanction in this criminal case against Mr. Allen. As a third matter of law almost older than dirt, a fixed sentence of imprisonment is punitive and criminal if it's imposed retrospectively for a completed act of disobedience, such as the contemptor, never heard that term before, cannot avoid or abbreviate the confinement through later compliance. Simply a flat, unconditional fine totaling even as little as $50 announced after a finding of contempt is criminal if the contemptor has no subsequent opportunity to reduce or avoid the fine through compliance. Some of this stuff happened months ago. So why bring it up now under a contempt of court charge? Even if all of it was fair and needed some kind of redress, which it doesn't, because things like the leak and Baldwin accidentally emailing his own work product, not the discovery, to the wrong person, weren't intentional, and the press release that Nicky really doesn't like, well, was before the gag order, and there was nothing in there that violates the Indiana Code for pre-trial publicity. Okay. As a fourth matter of law almost older than dirt. You see, this is the problem. Nicky is wet behind the ears. He's still quite young, isn't he? He's just out of his depth. You get all these old warriors coming out, charging on their stallions. And Nicky's there trotting along on his little donkey. I love donkeys, by the way. I don't want Nikki to have a donkey, they're lovely. As a fourth matter of law, almost older than dirt, if the state, by its information, is seeking punitive sanctions for indirect criminal contempt, filed its information in the wrong place. Yes, we have to keep repeating ourselves, simply because they have the reading ability of a centipede. The court has no authority to impose any punitive sanction for indirect criminal contempt in this criminal case against Mr. Allen. So, is the reason why Francis has called this hearing is to give Nikki a scolding, a piece of her mind, bend over and take 50 lashes for being an absolute clown? Is that going to be what the hearing's all about? Somehow, I doubt it. Francis, what you gonna do? What's your next move? It's like playing chess, isn't it? Yeah. I'll see you soon, guys. Stay tuned over on Michelle Walks for a video later on the Adam Montgomery trial. I'll see you soon over on this channel. I may be live if there's more filings later. Bye, guys.